Bonjour and welcome back. We will in this video discuss the digest of 1808. The title is From Code to Digest. You will have here to understand how, from the project of adopting a civil code in Louisiana, we ended up with a digest. And with this, in the next video, we'll try to figure out what difference it makes. And we will understand that this has serious ramification for the practice of the civil law in Louisiana still to this day. We had seen that there has been a struggle in Louisiana, and particularly in New Orleans, between Governor Claiborne, who tried to move the agenda of President Jefferson developing the common law and imposing the common law in Louisiana and satisfying the local population and reassuring them that things would go on like before. So from this tension came the manifesto that we have discussed in the other video and this act of June the 7th, 1806, where the Legislative Council and the House of Representatives decided that a civil code was to be drafted for the territory of Orleans, as Louisiana was then called, and the task was given to James Brown and Louis Moreteau. So this time, Claiborne had to bow to the will of the majority. However, he kept building a U.S. court system. A few words about the draftsman. James Brown, first, was born in Virginia. He had been a lawyer in Kentucky, where he served as Secretary of State. He was the first Secretary of the Territory of Orleans. He had been a district attorney, a U.S. senator. He even had been a minister to France, so he must have known some French. Louis Moreteau was born in Saint-Domingue, which was then a French dependency, and had received his legal training in France. He settled in New Orleans at the time of the purchase, moving away from Saint-Domingue, which was back then in turmoil. He was elected on the State House of Representatives, has been also a state senator, a parish judge, the attorney general, and a representative in Congress. So he has a significant political life, but was a very prominent lawyer. He has argued over 200 cases before the Louisiana Supreme Court, which for the time is enormous. He was one of the most famous attorneys in Louisiana, and particularly in New Orleans. You have here a portrait of Louis Moreteau. That's the book cover by Alain Levasseur. And is that James Brown? Maybe that one. Okay, and here you have, I love this, it's been sent to me by my friends at the library of the Supreme Court in New Orleans. Godfather of the Soul edition, a beautiful remake of the cover of the digest of the civil laws now in force in the territory of Orleans. Here you have a picture of drafting the digest. You can see this on the door going to the Senate in the state capitol. So compiling the digest was not a small business at a time when library resources were scarce. They didn't have computers, but the work was completed in less than 2 years, which is quite remarkable. A major source had been the French Projet du Gouvernement, published in 1800, which was the first draft of the French Civil Code of 1804, and the French Projet served as a model or a guide. Historians of Louisiana have established that they did not even have a copy of the actual Civil Code of 1804, though there are differences between the Projet du Gouvernement and the code as adopted in 1804. Think about this. codification in Louisiana is the first codification event that occurs after the adoption of the French Civil Code. We're talking about something big. And the second code presented here in Louisiana, the Napoleonic Code, just happened to be adopted here. So now, how did the French projet influence the draftsmen? It certainly influenced them in the form of the code. If you look at the table of contents, it's almost the same as the French. You have the 3 books of persons, of things, and different ways of acquiring the property of things. All subdivisions more or less mirror the French. And also regarding the substance, whenever French law was actually in accord with Spanish law, because remember, Spanish law was still in force at the time of the purchase, the draftsmen have, of course, largely borrowed from the French Civil Code. But as we will see, they have done more than this, okay? We should not conclude that the Louisiana text of 1808 is a copy, a carbon copy or a clone of the French Civil Code. This is not the case. By the way, this has been the origin of a very famous controversy, doctrinal discussion here in Louisiana between Professor Rodolfo Batizza at Tulane, who's been proving that about 75 or 80% of the articles of the Louisiana text were pretty close, if not identical, to the French Code. And Professor Pascal has said, nonsense. Of course, they have done that whenever French law did accord with Spanish law, but whenever Spanish law is different, they adopted different rules, which is right. I mean, Professor Pascal indeed proved that regarding the law of alimony, regarding matrimonial regimes and community of gains, you find the Spanish solution and not the French. However, further studies, like the one made by John Cairns, I presented his book on the previous video, studied the matter in depth, and he found out that in a number of instances, the draftsmen have made choices. They have been really weighing the solution of Spanish law as against French law, and sometimes moved away from Spanish law to adopt a French solution. One of the examples he gives relates to the pater familias, the family father. Spanish law was strictly following Roman law in the sense that if you were the son of a pater familias, if your father was still alive and you reach adult age, you would still be under the authority of your father until the father dies. By this rule, I would still be under the authority of my 95-year-old father. He's getting better, by the way. Thank you for your thoughts. So this was not a very convenient rule, and younger people wanted to be able to control their own affairs without asking dad to sign all the legal documents. So Morolile and James Brown resolved that it would be much better to decide that once a man reaches age of 21 years, you have full capacity, even if your father is still alive. So the French solution is adopted, the Spanish solution is abandoned. And this has been done in a number of other places. The book by John Cairns is fascinating. Another feature of codification of Louisiana, which makes it somehow different from the French experience, is the fact that Louisiana has been adopting a civil code out of a conservative attitude, which is very different from what we have seen in the context of France. And we have seen that in France, when the Code Civil of 1804 was adopted, it was clearly a break with the past. In the wake of the French Revolution, the purpose was to unify the law, that was pluralistic till the French Revolution, and also to move in an age of legislative positivism. Legislation would prevail over anything. Louisiana, adopting the Digest of 1808, just wants to assert the continuity of the law. There was no idea to change the legal system. By the way, there was no need to unify the law of Louisiana because there was already a uniform law in the colony. And the mindset of the New Orleans bourgeoisie, who has been pushing to the adoption of the code, was rather social conservatism. And also, regarding the approach to the law, you see a sort of natural law approach rather than legislative positivism. And by the way, this natural law approach explains why the draftsmen felt that they had quite a freedom to cherry pick and get the best solution, fitting the life conditions in Louisiana. They didn't feel that they had to codify Spanish law or French law. I come back to the Baptista-Pascal debate, but simply to do what was, in their opinion, the best for our territory, soon to become a state. It is also, and that makes it different from the French experience, a doctrinal codification. What do I mean here? Well, you find actually many definitions in the Digest of 1808 and in the codes that have been adopted ever since. Why that? The draftsmen were well aware that the majority of lawyers who would have to apply the Louisiana Code would have been trained in common law jurisdiction and would not be familiar with the civilian doctrines. And for that reason, they thought that definitions should be given in the code. You do not find these definitions in the French Civil Code because lawyers in France are trained at the university and they have a sense of what the words mean. So they had to find a source to give this definition. And the draftsmen borrowed from the French encyclopedist. The French encyclopedia of Diderot and d'Alembert was actually also dealing with the law, and it had been then republished into legal encyclopedias. And our Journal of Civil Law Studies just published a remarkable article by our foreign comparative and civil law librarian here at LSU Law, Seth Brostoff, The Encyclopédist Code, Ancien Droit Legal Encyclopedias, and their verbatim influence on the Louisiana Digest of 1808. So Brostoff is the first one to have clearly identified the origin of many of the definitions, a few hundreds of them, that appear in the enactment. So that makes the code much longer than the French was, and different in some respects. And it's fascinating, but that's for the legal historians to see whether these definitions that had been adopted here in Louisiana matched the conceptions that existed in France after the adoption of the Civil Code. If you want to read the article, I gave you a link. Our Journal of Civil Law Studies is open source. Another feature, and that also makes it different from the French Civil Code, we are dealing here with a bilingual codification. Indeed, the Digest of the Civil Laws now in force in the territory of Orleans, that's the title of the English translation of a code that was originally drafted in French and named Digeste des lois civiles actuellement en force dans le territoire d'Orléans. And you have a provision in the Act of March the 31st, 1808, that enacted the Digest into law. Section 5 reads that if in any of the disposition contained in the said Digest, there should be found any obscurity or ambiguity, fault or omission, both the English and French text shall be consulted and shall mutually serve to the interpretation of one and the other. That is quite remarkable because everybody knew that the code had been written in French and translated into English. And by the way, we found out later on that the English translation was not so good. Professor Palmer of Tulane is publishing a book about the translation of the digest, where there are lots of interesting information. But here you have a very modern, and it's maybe the first time that in a multilingual jurisdiction, you see the political decision to put both texts on an equal footing, which is a strong message to the English speakers in Louisiana. Feel confident, we are not going to betray your interest by saying, oh, the English says that, but the French is the source document, and of course the French must control. Eventually, by the way, this is what happened. Because the translation was so bad, our Supreme Court had to resolve, but further down the road, that the French would prevail in case of a linguistic problem. So the digest was adopted, as I said, on March the 31st, 1808. So almost exactly 4 years after the French Civil Code. It marks, and I insist, the formal recognition of the adoption of the civil law. And since then, the presence of the civil law has not been challenged in Louisiana. It doesn't mean, however, a full exclusion of the common law. As we know, civil codes are dealing with private law. They give the general private law, but there is much law that exists outside the civil code, and such law is in Louisiana usually or typically of common law fabric. This is the case for civil and criminal procedure. And by the way, we have the jury system. The court system, as I have already alluded to, is a typical North American system. The Constitution, once it was adopted, when Louisiana accessed to statehood in 1812, was actually copied on the Constitution of Kentucky, though it was bilingual, published, in fact, this time we translated an English text into French. And today, nowadays, the revised statutes that contain the big bulk of legislation applicable in Louisiana, including the laws about agriculture, fisheries, insurance, transportation, you name it, administrative law, education, etc. All this is dealt with in statutes that are written in the style of the common law statute, which is making us a mixed jurisdiction with a civil code that obeys to the canons of civil codes in civil law jurisdiction, and special legislation or statute that are of common law makeup. Also in the digest, you find things that are not exactly desirable by today's standard. A very bitter element, slavery, was codified in the digest. You do not find it in the French Civil Code because France had abolished slavery at the time of the Revolution. At least in mainland France, they made a dirty exception for Saint-Domingue, causing the rebellion of the slaves. But in Louisiana, the French population actually insisted on the French Black Code, le Code Noir, to be moved into the digest. And you had, regarding slavery, 3 different approaches. Okay, you had the common law approach, which was rough and really the hardest on the slaves. Slaves were really chattel. They were barely recognized as human beings. At least under French law, it was proper to baptize and give some education to the slaves, though you were not supposed to teach them how to read and write because that may give them just the wrong ideas. And you had the Spanish way, which was even more lax and generous on the slaves. They were slaves nonetheless and owned by other people, but at least the Spanish regime was milder than the French. And you see that the planters at the time of the purchase said, oh, let's move away from the Spanish system, which is a little bit too lenient, to the tougher and harsher French system. Professor Palmer has written Through the Codes Darkly, Slave Law and Civil Law in Louisiana, a short book which is remarkable. And Professor Rebecca Scott of Michigan has written several books and is visiting regularly in Louisiana. I've had a wonderful conversation on the subject with her. And if you are interested in the law of slavery and how it developed, do not hesitate to ask me questions. We are dealing indeed what was called the peculiar institution, l'institution particulière, and it is troubling when you get into there because, well, clearly you didn't have white people in slavery, okay? The white were rather slave owners and never slaves. With the black, it was a little bit different because you had free people of color and they were owning slaves. So black slave holdings was not unusual in antebellum America and particularly in the territory of Orleans. There are things, however, that did not make it to the digest. And I would like here to acknowledge the existence of the Indian tribes that we have in the region and their laws, because the Louisiana legal system is a pluralist legal system. We have a number of tribes, including the Atakapa, the Natchez, the Choctaw, to name but a few, the Caddo and Tunica more up north. And these tribes have their laws. You have here an excerpt and the preamble of the Constitution of the Atakapa, and could, by the way, invite one of the members of the council of this tribe, Dr. Dapour, a good friend of mine, and if you wish, we could spend a little bit of time with him, and he would tell you a bit about the custom and the usages and the laws of this tribe. I will conclude and finish with giving you access to the digest of 1808. It has been reprinted on a number of occasions, including in 2008, when we commemorated the bicentennial of our Louisiana Civil Code. And I have been in charge of putting together events and activities on the occasion of this bicentennial. And our main project at the Center of Civil Law Studies at LSU Law was actually to create a website that we call Digest Online, and it gives you free access to the text of the digest in English or in French. And in addition, you have the manuscript notes and the typed notes of Louis Moreau-Lillet, where Louis Moreau-Lillet is tracing the origins of the article to Roman law and Spanish law, especially. So these are tools that belong to you, that belong to everyone, and we will soon discover what happened, what was the content of this digest, how it fared in the courts. That will be the topic of the next video. I will see you shortly in a video that this time will be called From Digest to Code.